In this video, I'm going to discuss the exoneration and release of Lucy Letby, but this video is also going to be a kind of bookmark for myself. So I'm at a kind of halfway point in what I've been doing where I've submitted the final draft of my book and we're now working on the publication. And I suppose that completely inadvertently I've built up this YouTube channel and I've got quite a significant following now, for which I'm very grateful. So I had a little break over the last few days, and now the second phase begins, and that's going to be, obviously, the book will be released this year, and trying to make that as big and successful as possible, and trying to raise further awareness of how unfair this case has been. So I thought this would be an interesting way of bookmarking the campaign, if you wish to call it that, at this point. The first thing I want to remind people is that we've already traversed an enormous distance. There's no doubt that Lucy has more support than any previous British miscarriage of justice victim, and it's hard to imagine there have been many miscarriage of justice victims ever that have had this level of support. When I say this level of support, I mean over this kind of time frame. At a certain point, for example, the Birmingham Six had an enormous level of support, but it took a very long time. I mentioned previously that essentially nothing happened in their case for the best part of 12 years. For 12 years, they were just slammed away in prison. There you go. They're guilty. They're Irish. That's good enough. We don't need to assess the case any further. And it really took a quite concerted effort from journalists and broadcasters through a book. I think it was Chris Mullin, I believe, that wrote a very important book about the Birmingham Six. And then there was a World in Action documentary, and eventually the Birmingham Six were exonerated. Lucy is already in a much stronger position than that, and of course I hoped to write an important book that would perform a similar role to the one that I've just mentioned for the Birmingham Six. So that was my intention from day one, not just to write something that was read and reviewed and people said, well, it's good, and I was patted on the back a little bit. My intention was to write something that made a difference. So to get to this point where Lucy has so much support, there's been a colossal amount of effort from people on social platforms who comment on my YouTube channel, and then this has steadily engaged people in the mainstream, and more people have come forward, and we have an enormous amount of qualified, credentialed people now. As I mentioned in a live stream recently, just in the last few days, I've had another couple of very credentialed and very highly regarded people contact me. And there's more. This is happening more and more. It was tricky for me to decide even who to interview for my book, because I've probably been in contact with over 150 people by now who are experts, and then I don't know how many nurses, but conservatively hundreds are probably following me or have contacted me or have, commented on the channel. I don't think it's unrealistic to say that it might be 1,000. I don't know how many it is exactly. So there's an enormous number of people, and that's been instrumental in getting to where we are today. The other thing that I would really say about the Lucy Letby case is that it's revealed numerous major societal problems. The first and most obvious one, of course, is major problems in the criminal justice system, and these have become more and more evident to me the longer that this has gone on. I definitely came into this fairly naive and definitely not particularly knowledgeable about the court system, about the way the justice system works. And my view, I would say, when I began was simply plain wrong. And I must say, actually, that I wasn't utterly naive. I was aware of previous historic miscarriages of justice, but I did begin with the impression that typically you would receive a fair trial in Britain. I just simply do not believe that anymore. But even in the relatively early stages of examining Lucy's case, I felt that this could just be a particularly calamitous series of blunders, albeit it is calamitous. There were so many opportunities to stop this. But the more that I've examined this, the more that it's become obvious to me that there are really fundamental reasons why this has occurred and why it can occur again, and indeed why other court cases are unfair, and indeed why there have been a plethora of miscarriages of justice previously. So the first very obvious issue that's been established by the Lucy Letby case, and that is now becoming common knowledge, I would say, is that there are massive problems with expert witnesses in the court system. Now, it would be interesting for me to go back in time to the point when I first began researching Lucy's case. I often feel this about moments in my life or things that I've experienced. I have this desire to be able to go back in time and see how I felt, which obviously you can't do. You can't go back in time at all. But even when it's depicted in film, you can't go back and then reoccupy your own body from the perspective of where you were at some point in the past, or typically it's not depicted that way. But I often feel this in relation to numerous things, but I would love to go back in time to the point where I thought, well, Dr. Evans will start making some credible statements soon, and Dr. Evans will come out, and he's an expert witness after all. He will come out and he'll make some complicated medical assessment of something, or put forward some complex medical evidence, and it will require significant response, and it will be difficult to respond to. Obviously, I was extraordinarily incorrect about that assumption, but I had this. If you'd have said to me 3 years ago, this person is an expert witness, or even if you just said the term expert witness, I would conjured up in my image, in my head, this image of someone who's forensic, who's so professional, who's so measured, who's so serious, who has real presence. And of course, we know Dr. Evans has none of those things. It's quite extraordinary how inappropriate he would be to be any form of expert, let alone an expert witness in critical court cases where very major decisions are being made. And the fact that he has been in this court case, even after this letter, the infamous letter, the worthless letter, shall we describe it as, in which his evidence is described as worthless by Lord Justice Jackson. The fact that he's even in this court case in the first place is extraordinary. But his conduct since then goes beyond extraordinary into the realm of the surreal. And simply the fact that he has been in the court case, he hasn't been thrown out of it. We've seen what kind of person he is. We've seen his behaviour. We've seen his conduct. We've seen his intellectual level. That is obviously emblematic of major problems with expert witnesses in court cases. Of course, I've encountered other information, other news stories, other previous cases, the treatment of other expert witnesses, whether they were good expert witnesses or bad expert witnesses, that have obviously made me question this further still. The next major problem that's become very clear with the criminal justice system is the disparity in resources between the prosecution and the defence. Not only is the prosecution afforded more resources, but they're afforded a lot more time. Defence typically find themselves under time pressure. As described here, disparities in funding directly result in disparities in time, energy, and resources. So this has an enormous impact on the fairness of the process, and this could be a major contributing factor, almost certainly is a major contributing factor to why many people believe she didn't receive the best defence. As we've understood more and more about the court case and more about the background to what led to the court case, and some of the things that occurred in the police investigation, some of the things that have occurred with Dr. Evans and the other expert witnesses, of course, as I've established previously, they played a very minimal role in the court case. But the more that we've learnt about what went on, the more it's become clear that the defence was put in a difficult position and had a very difficult task. But if we were to accept for the sake of argument that the defence of Lucy could have been better, then one of the possible reasons for this is this disparity that has become very evident. And then another problem is that it's difficult to get defence witnesses. Prosecution can hire people who, it would appear, are willing to say almost anything. That this has been the case historically. There's now been numerous expert witnesses who've been involved in very serious prosecutions of the most serious crimes, who've just got carried away and started coming out with all kinds of stuff, and ultimately they've been discredited and disgraced. So this obviously predates the Lucy Letby case by a considerable distance. Now, I had no idea about this until I began to study this case, and I began to connect with people. I connected with one person in particular who has asked to remain anonymous, but this person knows a lot, and well, not a lot, they basically know all of these individuals that have previously been disgraced for behaving, shall we say, giving suboptimal evidence within the criminal justice system. Whereas defence has massive problems, particularly for contentious or controversial cases, in raising witnesses, so that skews things even further in the direction of the prosecution. So when you take that into consideration, it's hardly surprising that most people that go to court are prosecuted. It's nearly 80%, approximately 77, 78% of court cases result in a prosecution. Another problem is, I believe, the reasoning skills of the juries are not particularly great because they're just comprised of people from the general population, and I know the reasoning skills of people in the general population are not necessarily particularly great. And there's always a kind of prejudice, or a tendency to have this prejudice of thinking, well, there wouldn't be a court case, there wouldn't be all this stuff, it wouldn't be going on for so long, there wouldn't be the police here, there wouldn't be all these witnesses if there wasn't a reason for it to be taking place. It's kind of no smoke without fire theory that we've discussed previously. So I think all of these things make it harder and harder to defend someone. And the prosecution has all these techniques and tricks that have been developed over decades now. And then they're far from afraid to use them. They absolutely will use them. They'll use all manner of manipulation and what they know to be at best dubious and sometimes completely false arguments in order to win the case, because that's what they will just say. They'll use the Nuremberg defence and just say, that's our job. Our job is to prosecute. We've prosecuted, therefore we've done our job. I know when Anna was on, Anna Doherty, she didn't agree with that and she gave some views on this, but it's in a adversarial system, it can always be seen in those terms. So these are all massive problems for the defence and creates what is a very imbalanced and uneven system. And then another issue would be the Crown Prosecution Service. I don't wish to go into this in much depth, but I think this institution has very minimal ability to assess the quality of evidence in court cases. They have this two-stage or two-step process, and one of those steps often is meaningless because it's just, is it in the public interest to prosecute? And when it's a serious allegation, it's always in the public interest. So a lot of the times they don't even apply the second part of the process. They just have this kind of very minimal cookie-cutter approach, in my opinion, to the evidence. I don't think they have any ability, really. They certainly don't have qualified people or credentialed people to assess the calibre of evidence. And that kind of brings me on to my next point, which is that I think a bigger problem is just simply the ethos of the criminal justice system itself and its modus operandi. I think there is enormous complacency within this system and within the judiciary. I think there is this mindset and mentality that what happens is the prosecution gets some evidence together, the defence also gets some evidence together, the prosecution barrister and the defence barrister do a big performance in court, the jury makes a decision based on what it's seen, and then that becomes reality. The jury indeed is put on this bizarre pedestal whereby somehow they have this superhuman ability to discern what has occurred in an extremely complex case related to topics that they know nothing about when they walk into the courtroom. And yet you'll hear people like Liz Hull speak of the jury in such hushed and awestruck terms, as if they have some particular insight, when really it's just people from everyday backgrounds who've been called in on jury duty and they just do the best that they can. And a lot of people have mentioned the thing you can see on the screen now if you're watching this video, the Channel 4 jury murder trial film, which was apparently a very interesting insight into how different juries can draw completely different conclusions about the same case based on seeing the same evidence. Now, I'm not saying that always occurs, but I don't necessarily have an enormous amount of faith in juries. But the most important thing, really, as I say, is that you just there's a certain period of time that is given, and the prosecution will put evidence together. We've seen the calibre of evidence in the Lucy Letby case. We've seen what the prosecution has done in terms of fabricating evidence. We've seen the double standards of saying, all right, this evidential source is not valuable or not reliable when it exonerates Lucy, but it's 100% reliable when we can use it to demonstrate our case that we've fabricated. So the calibre of evidence that you see in court cases is not necessarily very good. And yet, in my estimation, having observed this case and now having observed other cases and trying to understand things better and better, it seems to me that the quality of evidence barely comes into the equation. In fact, I don't think it comes into the equation at all. I don't think there are any meaningful tests. I'm not aware of any mechanism that is used to test the quality of evidence. You can see on the screen now this article by Rhonda Wheat. This is for the University of Strathclyde. Why do judges keep letting bad science into criminal trials? And I haven't read this entire article, but one of the reasons, quite simply, is because they don't understand that it's bad science. And then another even worse reason is they don't really care, because they can't understand it in the first place, because they're not scientifically qualified, or medically qualified in this case, or qualified in finance is another major area where you can easily get miscarriages of justice because it's very complex and very technical. So they don't understand it in the first place, but I don't think they really care, because I say people in the judiciary, people in the criminal justice system, particularly, this becomes more true in my estimation the closer you get to the apex of the criminal justice system. They just believe in the system. They just think what a court case is process and procedure, and the evidence is, as long as it is procedurally sound, whether or not it's good, bad or indifferent is irrelevant. We just put a load of evidence in the court case, and then the supernatural jury with their superhuman ability just decides, right, we reckon this has happened, and then that becomes reality, and then they make it as difficult as possible to overturn that. When experts come out, when people who actually do understand the science, when people who do understand that it's bad evidence, when people who come forward to have considerably more credentials, experience, qualifications, etc., than anyone in the courtroom, not just the jury, the barristers, the judge, anyone that's even been involved in the process on any level, they will do anything they can to just delay, obfuscate, block, impede, and overturn and I guess hand wave this evidence. And the last thing they will ever do is try, and it has to be a last resort, is overturn a major judicial verdict, even if it's built on total rubbish. And they don't really care about that, because they just see that as the process. They see that as the system. They just see the system as being the processes and procedures that go into a court case, and then the arguments that are made in court by the barristers, who they are obviously qualified. They've got the King's Counsel, they've done the bar exams, they've done their bit as a junior barrister, they've done their time and risen the ranks, and so therefore somehow what they say is given a bizarre sort of credence, when in actual fact it often has absolutely no basis in reality whatsoever and has no credibility even. But it is given an automatic credibility because of the status of the people that speak it. And that's ultimately what happens in these court cases. It's clear as well that the police clearly struggle with assessing the calibre of evidence as well. I'm going to move on to discuss the police more shortly, but they share with it seems to me, and I don't know if this is an entirely fair impression, but I believe that it is a fair impression, that all the way through the system there are institutions, and people tend to head up those institutions who share this perspective, that are just simply focused on achieving a conviction. And a conviction is always a result. A conviction is always a positive because, I don't know, I think it's kind of an inbuilt bias of the system to just think, right, we've convicted someone, that's a success story automatically because there's been a crime, we've worked the crime out, and look, we've put someone in prison for the crime, so therefore it's a success. And the calibre of the evidence, both in terms of police investigations and the criminal justice system, is not really a major part of the process. It's just whether they can build a case, whether they think they can get it through the Crown Prosecution Service, and then whether it will go into court. And then once it's in court, anything can happen because the judges don't understand the case, particularly if it's in certain areas. And the court system, as we're going to discuss shortly, is not designed to get to the truth. That's not why it exists at this point in time, and it's certainly not optimally calibrated to get to the truth. Recently, I've been examining another case. I'm not going to go into details on this, but it was a case in which the defendant is definitely guilty. But it was interesting to examine this case because you see the same flaws and the same faults in the criminal justice system, even in a case in which the defendant is definitely going to go to prison, because the defendant is definitely guilty and should go to prison based on what the defendant has done. But actually, when you look at the court process, it becomes very clear that it's not a quest for truth. It's just a quest to secure a conviction. And that, in my view, is a major problem. And whatever lessons we learn from this process, it will remain a problem as long as we continue to have adversarial processes in every court case as a matter of course. Now, I think switching to even an inquisitorial system for some cases is going to be very difficult because there will be enormous institutional reluctance and resistance to such a notion, but it's become increasingly clear to me that courts just do not seek the truth in this country. It's not accurate to describe it as a conspiracy, but in a sense, the police, Crown Prosecution Service, and then the criminal justice system, they effectively collude to convict someone. Now, often they are correct to convict that person. In this other case that I've looked at, that it's absolutely a correct conviction. There's no doubt the person should go to prison. But the process and certain statements that are made in court, if you look at the court process as a whole, certain aspects are excluded from the court process. And then once the conviction is secured, you have statements that come out from the judge, and then statements that come out from the police, and statements that come out from the Crown Prosecution Service. And they are kind of indelibly written into the history of the case and the history of the defendant's public image, and they are presented as the absolute truth. Just as in the Lucy Letby case, the prosecution said the truth is, ladies and gentlemen, not the truth at all. It was absolutely supposition at the time, let alone now where we know there are so many flaws with the case. But it's actually very interesting to look at a guilty case because you see the same issues in the Lucy Letby case being repeated, even though there's absolutely no doubt this person is guilty and they've committed a really bad crime and they must go to prison. But that doesn't mean the process by which they ended up in prison was perfect. It definitely wasn't, because there were things that were excluded that are very important and that were brushed over quickly. And then in the public communication of the fact that this person had been convicted, certain things were presented as the truth when they're not really the truth. They're just the product of the court. And that's even more evident, obviously, in Lucy's case, where I strongly believe the defendant is innocent. But you can even see in a crystal clear guilty case, the process by which the courts arrive at that answer is far from perfect. The next very obvious problem that has been revealed by the Lucy Letby case has been systemic problems in the NHS. Now, these were very, very well publicised previously, but I would particularly refer to cultural problems. It's obvious that there are massive problems with whistleblowing in the NHS, and I think this headline here, whistleblowing in the NHS isn't fixed yet, and this leaves patients exposed, rather underplays the extent of problems with whistleblowing. It's not so much that it's not fixed yet, it's more that it seems that there's no effort whatsoever to protect whistleblowers, and indeed whistleblowers are far more likely to be targeted than even tolerated, let alone encouraged. It's absolutely correct to this headline to say that leaves patients exposed. It really is about safety. Ultimately, it's about patient safety. This whole issue is about whether or not hospitals can adequately look after the people they're supposed to look after, and whether they're going to learn from their mistakes, whether they're even going to try to learn from their mistakes. But it seems that there are massive cultural problems overall, where not only is it very difficult to be a whistleblower and very difficult even to tentatively point out, look, we're not doing this well, we should do it better, because of it's very difficult as an outsider to fully understand all the aspects of it, but I think it's fair to say that the hierarchical nature of the NHS plays a major role, and then those segments of the NHS workforce that are put on a pedestal seemingly run roughshod over everyone else, and it seems very clear that there is a bullying culture just from the amount of comments that I've read and the amount of people I've spoken to who said that there is toxicity and it's not getting better, it's getting worse. And then, of course, another issue that the Lucy Letby case has revealed is problems in the police. It is very clear that Cheshire Police had no idea how to run an investigation. That's becoming more clear every day. And there are two particularly bad things about this, in my opinion. The first thing is that I do believe Cheshire Police acted in good faith and tried their best. So given that their investigation was abysmal, that's not a great thing, obviously. And the second thing is I really couldn't say confidently that Cheshire Police are particularly poor. Now, they may be particularly poor, but I really couldn't say that with any confidence. It's quite possible that they're just of a very average standard for a constabulary in Britain, and that there are many other police constabularies that are of roughly equal standard or worse. I mean, that is a speculative comment, but I really couldn't say with any confidence that Cheshire Police are particularly bad. Clearly they're bad, that's quite obvious, but I couldn't really say that they're definitely worse than other police constabularies. They could be around the median average, for all I know. So that brings us to the question of when Lucy will be exonerated. So it's obviously difficult to give a precise answer to this question, and I know people want to be optimistic and people don't want to hear bad news about something that is very important that we all, I would assume anyone that watches this video cares about very deeply. So I think there are three scenarios initially that I'll just discuss. The first one is the incredibly optimistic scenario. This would involve Dr. Evans withdrawing his evidence or one of the consultants having a moment of actual conscience, and this could result in Lucy being released this year. Even the consultants coming forward may not be enough, because Dr. Evans, I cannot see him withdrawing his evidence and he would still say, well, I still think it's a safe conviction. That's the kind of person he is. He's never going to admit that he's wrong, even after he's proved wrong. He'll take it to his grave, the idea that he's always been right about everything. As far as he's concerned, it's impossible for him to be wrong about everything, which is ironic considering he's not a particularly intelligent person, he's not particularly articulate, often he's not particularly coherent even. So I find the level of conceit that he has is actually emblematic of the corrosive culture in the NHS I've just described. It's because he was put on a pedestal, he was always deferred to, as he described it, to use his own words. And eventually, if you're vulnerable to conceit, and if you're vulnerable to arrogance, you can become something of a monster, certainly in the ego department, and that is essentially what he is. So that's why you see him talking about other topics as if he's some sort of authority, when in actual fact he knows nothing. And that's why you see him in this new case, where it's a shaken baby case and he's giving evidence in an area where he shouldn't be giving evidence, because he just thinks he's right about everything. And I don't think the incredibly optimistic scenario will happen for 1 second, but it's possible. The second one is an optimistic scenario in which the Criminal Cases Review Commission refers the case in 2026. The Court of Appeal exonerates. There is no retrial because it is accepted that there is no way that this can feasibly take place, and Lucy is released in 2027. I suppose that would depend on a timeline. It could also be 2028. And then the third scenario would be the Criminal Cases Review Commission refers, the case collapses at the Court of Appeal, and there is then a retrial. So I heard Mark MacDonald speaking about this in Manchester, and he was talking about 2029 or even 2030 being a possible date for a retrial. Now, I can't. Mark, that's not set in stone. I must emphasise that Mark does not know that is the case. He's just basing this on his knowledge of the criminal justice system, which is significant, obviously. What we do know is that there is an enormous backlog of cases generally within the court system, but a mitigating factor is, if this case collapsed at the Court of Appeal, there would be enormous pressure to expedite the court case. So I'm not sure it would drag on quite as long as Mark suggested, but again, that is purely speculative from me. There is no possible way for me to know. And he suggested a timeline of the Criminal Cases Review Commission refers this year, possibly around the summertime, although he doesn't know, no one knows. It really is a how long is a piece of string situation. And then there could be 8 to 10 months for the Court of Appeal process to take place. And then he was talking about an 18-month delay for the case to go to court. So that would mean the trial would then take place in 2029, if that timeline was to occur, roughly speaking. So the question would be, what is the likelihood of a retrial? So Mark seemed to think a retrial was basically inevitable when the case collapses at the Court of Appeal. Now, I know a lot of people don't share that view. In the comments section, many people have said to me there won't ever be a retrial because there can't be a retrial. And I don't know whether that's true or not, but I do agree that I don't see there being much of a prospect of there being a retrial, because these 4 factors that are on the screen now, it's impossible to use the statistical case from the first trial. There would have to be a significantly different prosecution case, as the original prosecution case can't be put in court without being annihilated. The prosecution would struggle to raise witnesses, not least because they would know what they were up against. The medical information used in the first court case has now been savaged by literally hundreds of medics and scientists of the highest calibre. So when you put those 4 things together, it's going to be extremely difficult to put this case in court for a retrial. On the other hand, it's going to be enormously embarrassing for the Crown Prosecution Service to say, well, we're not even able to go back to court. But then again, if they do go to court, it's going to be enormously embarrassing when they are slaughtered in court by the already 29 experts, and it will probably be more by then, that have been assembled by Mark MacDonald across every conceivable specialism of enormous calibre and the very highest quality and status. It is inconceivable that the Police and Crown Prosecution Service will be able to put together a panel of experts that is even remotely close to the same standard. And that would be true under any circumstances, but it's very obvious that experts are going to be wary of going to this court case because it can stick to them for the rest of their careers. So I literally don't have the slightest clue whether there would be a retrial or not. I can't see any conceivable way that there can be a retrial, but I also recognise if the Crown Prosecution Service has to say, in this enormously important court case, that's one of the most important court cases in British history, well, if it secured this massive conviction and successful prosecution. I don't like the term successful, but they will view it that way. And this woman's facing the stiffest penal sentence a woman has faced since the abolition of the death penalty. But we can't even go back to court and put evidence in the court because the original case was so poor. That's going to be enormously embarrassing. So it's going to be so difficult for them to decide what to do next if the case does collapse at the Court of Appeal. So it'll be interesting to see. Finally, I do just have to mention, and it's not something that people wish to contemplate, and I understand the reasons for this, and it's not something that I particularly wish to contemplate either. But Lucy's not guaranteed to win her appeal. It may seem inevitable, and I know there's optimism, and I hope that she does, obviously. But we must face the reality that it is not absolutely inevitable. The Birmingham Six didn't win their first appeal. It's very, very difficult to win a first appeal. There has to be a very high standard of evidence. I believe that is in place in this case, and I'm hopeful, and I'm even optimistic. But we cannot be complacent about, we know that Lucy's innocent, so she'll now definitely be exonerated. It's very important we keep up the pressure on the system and expose this more and more. And I recognise this from day one, which is why I've committed to doing this, why I've committed to doing this channel, why I've written my book, and why I've taken time out of my own life and made sacrifices in order to do this, because I recognised in previous cases public pressure was key. I've quoted many times this guy Paddy Hill who was in the Birmingham Six, saying it wasn't the court that exonerated us, it wasn't the government that exonerated us. I'll tell you what exonerated us. It was public pressure and public outcry. And that's what makes a difference, and it's vital in the case. And that's why when we'd reached the point in the New Yorker article, when there'd been the Guardian article and the Daily Telegraph article, I knew that the coast was clear to write a book that could be published and that could help Lucy, hopefully. That was the goal from day one. So that's why I've committed to this, to help. But I'm just one person. It's everyone else needs to help as well. You've already done a phenomenal job on social media, supporting many different people on YouTube, on Twitter, on other platforms, people that have been in the mainstream media, etc., etc. I think that the effort that's made has been superb. But it's important that we do everything possible to keep up the momentum and pressure, because, as I say, the Court of Appeal has refused appeals from many innocent people in the past. So please don't underestimate that. I think ultimately what we're looking at with the Lucy Letby case and with criminal justice going forward is a choice, and it's really a choice for the younger generation as well. I'm probably going to be on the earth for less years than I've lived so far. So it's really up to the people that are growing up now to decide what kind of world they want to live in. Do they want to live in a world in which there is this idea that the court system is completely trustworthy and that it doesn't make mistakes, and that when someone is convicted it's always a safe conviction? Or do they want to face the reality, the grisly truth, that there are major, major problems with the criminal justice system, and that it makes mistakes all the time, and that not only does it make mistakes, but the very processes that are at the heart of the criminal justice system are fundamentally flawed? This case has revealed that to be, in my view, undeniable. It really is a choice between these two things. And for a long time, I think my generation and the older generation have preferred comforting lies, or at least a comforting perspective, over the unpleasant truth. They have wanted to believe, and I'm guilty of this myself, that you are guaranteed a fair trial in this country, and that the criminal justice system is fit for purpose, and that the institutions that comprise the criminal justice system are fit for purpose. If there's one thing that the Lucy Letby case has made absolutely crystal clear, clearer than crystal, is that this is emphatically not true. That the criminal justice system is not fit for purpose, it's antiquated, there are massive problems, and there are massive problems with the institutions that ultimately result in cases being in court. And it will really be now for the younger generation of people to decide whether they want to continue to go along with this, whether they want to continue to swallow the comforting lies, or whether they wish to face the unpleasant truth.